Thank you, Mr. Speaker. I'm grateful to the honourable gentleman for his question. This remedial order is a clear signal of the government's commitment to legislation that can command support across Northern Ireland. Its purpose is clear: to formally remove some of the provisions in the Northern Ireland Troubles Legacy and Reconciliation Act 2023 that were found by the courts in Dillon to be incompatible with our human rights obligations. Specifically, this means removing the provisions on immunity from prosecution and the bar on Troubles-related civil cases. Although the immunity provisions never commenced, it is essential that we formally remove them from the statute book. It is the government's belief that there are compelling reasons for proceeding with this order, and this is a view shared by the Joint Committee on Human Rights, which in its report on the 9th of December agreed that the government has such reasons and recommended that Parliament approve the order. The committee stated that, and I quote, "In these exceptional and unusual circumstances, the government has sufficiently compelling reasons to proceed by way of a remedial order." I want to set out what the government believes those reasons to be. Firstly, we must provide clarity on immunity and remove the bar on civil claims as quickly as possible. This is essential for all involved, victims, survivors and veterans, and is a prerequisite for building trust. Secondly, providing this clarity is vital to enable the Independent Commission for Reconciliation and Information Recovery to continue its work. It is my view that while immunity, a key plank of the 2023 Legacy Act, remains on the statute book, it will be difficult for ICRIR to obtain the confidence of all victims and survivors. As the JCHR rightly noted, the legacy of the past continues to have a profound and lasting impact, and we know that families and political parties were vehemently opposed to the immunity provisions. While the repeal of immunity is only one aspect of reforming the arrangements put in place by the 2023 Act, I am confident that its repeal will result in a greater confidence for referrals to be made. Given that many individuals are elderly, they cannot keep on waiting. It is the government's view that these changes should therefore be made through the remedial order as soon as possible. Mr. Speaker, the government has a clear mandate, compelling reasons and a procedural basis which the JCHR has endorsed, and the House will have an opportunity to debate the order in the new year.
Thank you very much, Mr. Speaker, for granting this urgent question, which I've asked because I think that there's a very real danger that the government may be about to break the law. And it's very important that the House is aware that the Joint Committee on Human Rights was not in possession of all of the facts when it wrote its report. Last year, the High Court in Belfast found parts of the Legacy Act to be incompatible with the European Convention on Human Rights. And at the time of the last election, the Conservative government was appealing that highly disputable decision. The incoming Labour government, for reasons it's never disclosed, chose to drop that appeal and subsequently has laid a draft remedial order to amend the legislation. Now, the problem with this, Mr. Speaker, is that earlier this year, the Northern Ireland Veterans Movement was granted permission to intervene in the case before the Supreme Court. And on the 15th of October this year, Lord Wilson Casey, acting for the movement, did just that and gave written and oral submissions which the court are now considering. Consequently, it's entirely possible that the declarations of incompatibility relied on by the Secretary of State to lay the remedial order will be quashed. The case is very much live, and this is very important because under Section 10 of the Human Rights Act, a government only has the authority to use a remedial order unless and until all appeals in relation to declarations of incompatibility have been determined or abandoned. This test is not met. And if the government decides to push ahead with its remedial order, not only will it be acting ultra vires, it will set a terrible precedent which will mean that future governments may use remedial orders in ways that they were never intended to use. To avoid this, all the government needs to do is to commit to not pushing its remedial order to a vote until the Supreme Court has finally ruled. Will the Secretary of State make that commitment?
Very well done. Secretary of State.
Well, I'm grateful to the honourable gentleman for the point that he has raised, but I would say to him that the argument he puts is not correct. The appeal was abandoned by the government in July 2024. And he says, for reasons that have never been disclosed, the government has been absolutely clear from the beginning, we disagree with immunity and we are committed to repeal and replace the Legacy Act. And Section 10 gives a Secretary of State the ability to make a remedial order when a declaration of incompatibility has been made and any appeal has been determined or abandoned. It has been abandoned by the government. Now, the honourable gentleman has suggested that the ongoing Supreme Court appeal in Dillon means that the conditions have not been met and therefore suggests that we may lack the virus to lay this order. I do not agree with his assessment and have made the position clear to the honourable member in the correspondence that we have had, I think an exchange of 2 emails and 2 letters. I can confirm to the House that in July 2024 the government formally abandoned its appeal concerning the declaration of incompatibility relating to immunity from prosecution. That declaration was not part of the appeal that is now before the Supreme Court. And the fact that the Northern Ireland Veterans Movement was granted permission to intervene does not alter this legal reality.